This is Michael from Blue Sky Bio and Bio Big Box. I'd like to welcome everybody who's joining us for tonight's presentation. We'll wait just a bit longer to allow people to log in and join the presentation. Okay, just a word about Bio Big Box while everybody's joining. Bio Big Box is a newly launched HIPAA-compliant file transfer and storage system developed by Blue Sky Bio. It allows the transfer it allows files to be transferred and received using a HIPAA-compliant system at no cost. Has great built-in features, including 3 gigabytes of free storage, files that don't expire, don't disappear. It notifies you when the receiver downloads the files, and many other great features and functionality as part of the free plan for Bio Big Box. Users could also upgrade to receive additional storage, a personalized upload page with your own background and logo, and many other features as well. For those of you who know Blue Sky Bio and Blue Sky Plan, know that once we get started on a project, just stay tuned. The project and the functionality keeps getting better and better, and we encourage everybody to go to biobigbox.com, try it out, and stay tuned for updates as new features and functionality comes out. The topic of tonight's presentation is how serious is HIPAA, what you need to know about your digital information. We have the pleasure tonight of hearing from Mr. Brian Tuttle. He is a HIPAA expert, specifically in the field of IT, with 17 years of experience consulting and helping different medical businesses. Without any further ado, I'd like to pass the presentation over to Mr. Brian Tuttle.
Thank you very much, Michael. Again, my name is Tuttle. Getting a feedback, Michael?
What's that?
Are you hearing a feedback?
No, we're hearing you just fine.
Okay, great. Again, my name is Brian Tuttle, and again, as Michael said, I've been working in the healthcare industry about 17 years doing compliance consulting for HIPAA, IT security, and as of the last few years, there's been a very large uptick in our concerns with HIPAA because the federal government is serious with this now, and there's money in place to enforce it. In the past, this has been a pretty benign area because what good is a law if there's no funding to enforce it and it's not being done? So that has all changed, and I've done hundreds and hundreds of risk analysis for covered entities, which are what dental practices are, as well as any other medical practice, and also for business associates such as Michael's group or any business that is privy to private health information in order to help a dental practice or a medical practice achieve its goals. Those are considered business associates, and now they are under the scope of HIPAA as well. And it's important for medical practices and covered entities to understand the importance of having good business associates, because if you do not, it can leave you liable to some pretty nasty fines. So without further ado, let's go ahead and jump in here, and I hope everyone can see my screen. I'm not going to spend a long time on the history of this law, but HIPAA, the Health Insurance Portability and Accountability Act of 1996, was enacted by the U.S. Congress and signed into law by President Clinton. Initially, on its outset, there was nothing at all in the acronym HIPAA, Health Information Portability and Accountability Act, which had anything to do with privacy or security. It's a very small subset, and it didn't even come out until 2003 for all intents and purposes, where the privacy security aspect of this came into play. Because when you think HIPAA, most people think, you know, be quiet, don't disclose private health information. But there's a lot more to this law than just that. Obviously, in this speech, we're going to be speaking to the privacy and security of private health information, because that seems to be the biggest enigma and the most difficult piece of this legislation that covered entities and business associates both struggle with. So the law is also known as the Kennedy-Kassenbaum Act, named after its two major sponsors, Senator Ted Kennedy, Democrat, Massachusetts, and Senator Nancy Kassenbaum, or Kassenbaum, Republican, Kansas. So we can blame both parties for all of the fun red tape we have to deal with HIPAA privacy security. Okay, next slide. So again, like I mentioned a minute ago, HIPAA is an acronym for the Health Insurance Portability and Accountability Act. The original goal of HIPAA was that you could, as the word portability explains, that you could have your insurance, even if you lost your job, there was a way to have portability of that insurance for a period of time until you got a new job. So you weren't just cut and left out to dry without any insurance. That's bad, obviously. But there's a lot of little titles to HIPAA, and it's under Title II with HIPAA, where we're dealing with privacy and security. Under one small subset of 5 titles under Title II, the administrative aspects of this, privacy and security, that's where it is. Not that that's very important to know, but just to understand, privacy and security never were at the onset a big part of the HIPAA legislation, but yet they do present our largest challenge. Here, real quickly, are the 5 titles of HIPAA. Title I, which was healthcare access, portability, and renewability. Then Title II, which is what we're dealing with, preventing healthcare fraud and abuse. The administrative simplification, that's in red, because under that title is where we find the medical coding. That's where we find HIPAA privacy and security, is under that little subset. Then you've got medical liability reform. Then you've got Title III, which offered tax-related health provisions. Then Title IV, which was application and enforcement of group health plan requirements. And Title V was revenue offsets. So all we're really dealing with, again, is Title II administrative simplification, because that is where the privacy and security rule of HIPAA reside. So I mentioned a little bit earlier about this law in the past was benign. It really was, because again, what good is a law if it's not being enforced? In the past, it was not enforced. Unless you had a major breach, perhaps you might get an audit. Well, nowadays, the government is proactively auditing folks, not reactive. They're outsourcing this to multiple firms and individuals such as myself. I have worked on behalf of the federal government. So in a way, I don't like doing that, because I don't believe in how this law is being implemented, because this law is very gray. The government tells you what to do, but they don't tell you how to do it. So the auditor is the judge, jury, and executioner here. And in being an auditor for the federal government and seeing what they look for, it's nice, because I can carry that on to my clients and say, look, guys, this is what you need to look for, because this is what the federal government is looking for. And again, the boy who cried wolf, this law was like the fable. It's been very benign all these years, but finally the wolf has arrived. The government's been saying all these years, you need to do this, you need to do this, you need to do this, but they did not enforce it. Now it is being enforced. And I'm getting calls every single day, emails every single day from medical practices, dental practices, IT companies, insurance plans, anybody dealing with the HIPAA privacy and security are now under the gun, so to speak, of the federal government. And because the federal government is outsourcing all of this to external entities, they're able to reach a lot more than they were before, just using, quote, federal employees. All right. So again, before HIPAA, before September 23rd, 2013, which is when this thing called the Omnibus rule came out, was sort of like this poodle. It had some teeth. It had a loud bark, but you could kick it off your leg for all intents and purposes. After Omnibus, and this is, funny but true, after Omnibus, it's more like the honey badger. You cannot kick one of these off of your leg. They'll take down a lion. But it's funny but true, because the facts are what they are. Auditing has increased now. There's been more federal audits in the last year than the entire history of the legislation. The federal government has put out more fines for HIPAA in the last year than the entire history of the legislation, because they're outsourcing this. Number one. Number two, because the federal government are asking states' attorney generals to let their citizens know, or to empower their citizens to sue for HIPAA violations. They're not suing under federal law, but they're suing under state law. Therefore, you're getting a higher uptick of HIPAA audits, because more individuals are learning that they have an individual right of remedy for wrongful disclosures using their state laws. And in order to get paid under your state law, the individual first must file a federal complaint with Health and Human Services on a HIPAA violation. So we're getting hit from both sides now. The federal government is suing private practices and business associates and anyone dealing with private health information from that side. And now the individuals who are wronged also are coming from the other side. So it's a perfect storm, if you will. And the bottom line, and I'll say this throughout the whole presentation, is you've got to be proactive and not reactive with this. The worst thing you can do when dealing with an audit is to not have anything in place. Get your risk assessments done, get your policies in place, get your staff trained, make sure you understand what to do. This is not rocket science. It's just very important to be proactive and not reactive here. All right, moving on. So again, 9/23/2015 is the D-Day, at least in my world, for the HIPAA Omnibus rule going into effect. And what that primarily did is it enforces the laws already on the books for covered entities, and for business associates, it equals the burden. Now business associates get to enjoy all of the fun. They have to have their risk analysis done. They have to have their own policies and procedures in place. They have to show that they're training their staff, that they're auditing any systems they may have containing private health information, just like just like the covered entities. So again, not to be redundant, but September 23rd, 2013, the HIPAA Omnibus rule went into effect. This increases penalties. It equals the burden between business associates and covered entities. And just to be clear, I'm sure you guys understand what the difference between a covered entity and a business associate. A covered entity is a provider. A provider, it could be a dental practice, it could be a medical practice, hospital. It's also insurance companies, labs, clearinghouses. Those are providers. Business associates are typically, let's say, an outsourced medical billing company, an outsourced transcription company, an outsourced IT company. It could be an attorney who may be privy to private health information. It could be an answering service. It could be a collection agency that's working on behalf of a covered entity to collect patient information, because those groups are privy to private health information to do their job. So moving forward here, it also enforces what was already on the books for covered entities, and it did add a few little idiosyncrasies and wrinkles for the covered entities, but it is enforcing what was already on the books. And it greatly enforces and increases the federal auditing, because the Health and Human Services is now empowered with a budget to do so, and also because the Health and Human Services is asking states to implement their own laws that folks can be remedied for wrongful disclosures, individuals. All right.
If there are questions during the presentation, then please enter them into the chat box, and
yes,
they could be addressed throughout the presentation.
Absolutely. If you have any questions, feel free. This is an open forum. A little more background. The 2009 HITECH Act which was also part known as the American Recovery and Reinvestment Act, it gave a lot of teeth to the HIPAA security and privacy rule, but still no funding. The Affordable Care Act, there's a lot of funding in that gives mandates and money, more than anything, to the Health and Human Services to start utilizing the Office of Civil Rights to begin auditing covered entities and business associates. Why is it that the Office of Civil Rights is the wing of government that enforces HIPAA privacy and security? The reason is it is your right as an American that your private health information be secured. The burden is on the business associates and the covered entities to ensure that that information is being secured to a reasonable and appropriate level. Because historically, let's face it, healthcare has been terrible about securing anything. It's just not had the mechanisms in place to secure the private health information. It just hasn't been done. And you've got your name, your address, your social security number most of the times tied to this record. There's a lot of information there. And so that's one of the reasons the government's so hardcore on getting this done. The other reason is because we're moving to what's called health information exchanges, meaning all of our information is going to be electronic, our private health information. And it's going to be in an exchange up in the mysterious cloud somewhere. And all of these electronic health record systems throughout the country will talk to each other. It's good in the sense that if you get injured in San Francisco, the doctor out there, if you're on a gurney and unconscious, can see your health record and not have to call your primary care physician back in South Georgia on a Sunday who may be fishing. So that's a good thing, but on the other hand, it does open a gigantic can of worms in terms of risks. So moving forward, the Health and Human Services has begun awarding multiple firms contracts to carry out these audits, and it's not just firms, it's also individuals. And there's a catch-22 here, because if a firm or an individual is given a contract to carry out the HIPAA audit process, is it not in that firm or individual's best interest to find something wrong? Because if you find nothing wrong, you're going to lose the contract. And quite frankly, with this law, considering it's so gray, considering there are no finite answers here, there's so much subjective areas that can be found to be fault. So again, I keep harping on this, the importance of being proactive and not being reactive. I've seen firsthand where some groups have actually better security of their private health information and security just in general, of physical security, administrative security, technical security, but they've done no risk analysis. They have no policies in place. They've never trained staff. Staff have not signed any confidentiality agreements. They've never audited systems that contain private health information. Even though they have very good security, they get bigger fines than groups who have kind of shabby security, have real life security shabby, but they have done risk analysis and put policies in place. They tend to do a little bit better. And I hate to use these words, but it is what it is. The illusion of security in a way is almost as important as the real security itself. Not exactly, but showing effort is extremely important when dealing with federal bureaucrats. Okay, so moving on here. Real quickly, just again, HIPAA has historically been a benign law, no consequences for actions in most cases, more of a nuisance than a real problem, kind of like the poodle, then it became the honey badger. Fines were low and rare, audits were low and rare, and only in the past could Uncle Sam sue for major HIPAA violations. That is not changing. Government will always be getting their share. Uncle Sam will still be suing no matter what for a HIPAA violations that are found to be when the entity has not shown due diligence to put in mechanisms to lower that risk. But the government, again, is asking the states to implement their own version of this so the individual also gets remedied, because nowhere in the federal law was there any interest in the beginning for the individual who's been violated to get paid. So that's changing. Can you or me be arrested for wrongful disclosure of private health information? Technically, yes. It's very important to constantly reinforce that to your staff. If you do something in a malicious way or a very careless, wanton neglect kind of way, yes, the individual can be fined, not just the business. So it's very important to reinforce that to staff. When they realize it's them that can be individually on the line here, or that gets fined and technically thrown in jail, they tend to listen more. And now, don't get me wrong, I'm not trying to scare folks. This would have to be malicious, such as going on Facebook. And this has occurred. This is an actual case. A young lady goes on Facebook, my ex-boyfriend came into the clinic today and he has a, quote, disease. And she posts that on Facebook, and therefore that's malicious. Maybe the guy deserved it, who knows. But $10,000 fine, month in jail. That's a malicious wrongful disclosure of PHI, or stealing identities, things like that are malicious. Can the practice or the business be fined for HIPAA violations even if a breach does not occur? Yes, even if a breach doesn't occur. In the past, you could only be fined under HIPAA for an actual breach. But now you can be fined proactively even if it doesn't occur. Think of it like OSHA. There's a wire across the floor. No one's tripped over it yet. Someone could potentially trip over it yet. Therefore, the OSHA man fines you. Same with HIPAA. An auditor comes in, you've got no policies in place, you have no disaster recovery plan, you're not training staff. Your server, for example, is sitting in a non-secured area of the practice. Those kind of things, little nuances like this, can get you fined proactively because of the high risk of a potential breach. Next slide. Real quickly, what's the definition of a business associate? It's very important. Even if I'm not speaking to business associates on here, you guys need to understand the importance of having good business associates. A business associate is an individual or an entity that creates, receives, maintains, or stores private health information on behalf of a covered entity. Again, the examples: answering service, medical transcription company, IT groups, billing company, shredding services. Those are all clearly under the auspices of business associates. And it is important for you covered entities to get good assurances that your business associates are in fact securing your private health information in a HIPAA compliant manner. Very important. Similar to like Michael's group. They are securing the information in a HIPAA compliant manner, because if your business associates are not, and they get audited by the federal government and they have holes in all of their compliance, HIPAA compliance policies and procedures, then that can actually come back to bite the covered entity. The business associate is going to get fined by the covered entity, but then by the federal government. But then the federal government is going to ask the covered entity, well, wait a minute, why were you guys allowing these folks to store your patient's private health information, knowing good and well they weren't storing it in an encrypted fashion, or knowing good and well they were accessing your business in a non-encrypted fashion, knowing good and well they were emailing you Word documents non-encrypted with private health information. Things like that. That can actually come back and bite the covered entity. Next slide. So the audits have begun in earnest. Audits are targeting practices and business associates of all sizes. Doesn't matter, big, small, short, tall. It's kind of sad, but these smaller groups tend to not fare as well as the larger groups. Makes sense, because they don't have the money and the budget to have to pay a full-time person to deal with this kind of thing. It's just typically not high on the priority list. Clearinghouses and insurance companies are also at risk because they are, quote, covered entities. The federal government is not accepting the same old excuses anymore. They are just not anymore, not like it used to be. So let's talk a little bit more about your business associates and how things have shifted. The Omnibus rule requires business associates now to comply directly with HIPAA regulations themselves. And once again, why it's very important for you covered entities to understand that your business associates now need to have their policies and procedures for HIPAA in place. They need to have staff training. They need to conduct risk analysis. They are subject to federal inspections. And this is a catch-22. Business associates have to monitor covered entities where a business associate agreement exists. For example, if a business associate notices a covered entity, even a client, is doing things in a non-HIPAA compliant manner, business associates need to let that covered entity know, which is a weird sort of law because typically the covered entity is paying the business associate. Like if a outsourced billing company notices a covered entity is sending them a whole bunch of Word documents in a Yahoo email account, non-encrypted, they need to tell the covered entity, look, this isn't HIPAA compliant. You guys need to stop this. Because if it's found out, again, through an audit of the covered entity, that they were sending these things to their outsourced billing company, then guess what? The federal government goes to the billing company and fines them too for not putting a stop to that. Big catch-22. So very important to have good business associates and good covered entities. It's a working relationship here. Business associates are also subject to the breach notification rule, meaning if there is a breach by the business associate, they need to notify the covered entity. So penalties. Penalties are much worse now. Omnibus has increased penalties up to $50,000 per violation to a maximum of $1.5 million for repeats of the same violations. And I have seen the $1.5 million fine given out on a couple occasions. Fortunately, it was argued down. You can appeal these things, but we got it argued down. And it was all based upon taking no due diligence and not being proactive. In all accounts, this has occurred when the government comes in and you have not taken this seriously, you have not implemented a reasonable and appropriate risk mitigation, that's when they nail you. Health and Human Services is now required to impose these penalties when violations are found to be willful. And again, criminal provisions are applicable to individuals as well as the organizations, whether it be a hospital, a practice, or a business associate. So what constitutes a breach? A breach is any impermissible use or disclosure of private health information, and it's presumed to be a breach with the subsequent requirement to provide those individuals a notification the breach occurred, unless the covered entity or the business associate can demonstrate there is a low probability that the private health information has been compromised. And one thing to remember, the burden is on the covered entity and the business associate to prove that notifications were provided or that a breach did not occur. If a breach occurs, it is known that a breach occurred. You do not notify the patient. That is a $150,000 fine. You may say, well, they'll never catch me. And speaking from experience, I'll tell you how you get caught. You get caught by a disgruntled internal staff member. I've seen this way too many times to be comfortable with, but internal staff members tend to be the problem here. If a breach occurs, you must notify that patient or patients that it occurred. If you want any more information on breach notification, you can go to hhs.gov, meaning Health and Human Services.gov, and just put in the search breach notification policy. It'll give you a little policy, tells you exactly what to do if a breach occurs. And let me be clear, breaches occur all the time, and that's normal. They do. It's incidental disclosures. There's all kinds of ways these can occur. It does not mean the end of the world. It really doesn't. The government's not even going to fine you anything if a breach occurs and you have taken reasonable and appropriate risk mitigating steps, because it can occur. But if you do not notify, that's when things get really bad. So moving forward, what determines, again, if a PHI has been compromised? You want to consider the following things here. And another thing, on hhs.gov, you can find a breach incident investigation form. It's just a little investigation form that you can go through, and it tells you, answer a few little questions, whether it's likely a breach occurred or it's unlikely if a breach occurred. So, covered entity or business associate must consider the following: the nature and extent of the private health information involved, including the types of identifiers, the unauthorized person who used the PHI or to whom the disclosure was made, whether the PHI was actually acquired or viewed, and to the extent which the risk has been mitigated. I'll give you a couple of examples. For example, if you mail a letter with private health information to the wrong address, the person from the wrong address is nice enough to bring it back to the office and say, I don't think this was for me. You look at the letter, it has not been opened. So you do need to write a breach incident investigation. This is what occurred. This is why we feel that private health information was not actually viewed because the letter has not been opened. Therefore, this is not a breach. We do not need to notify. Another example, if you lose a laptop computer that has private health information on it, but that laptop computer is encrypted, you do not need to notify the individual. You want to fill out the breach incident investigation saying, here's what happened, and here's why we conclude this is not a breach because the laptop had 256-bit blowfish encryption on the hard drive. So that's not a breach. However, flip it around, it is a breach. With no encryption on the laptop, that's a breach. Letter comes back, it has been opened, that's a breach. Then they need to be notified. Just a couple very simple examples right there.
What would be an example of somebody sending you, let's say, a CT scan using a non-HIPAA compliant system? What should the receiver be doing?
If someone's sending a CT scan, the non-HIPAA compliant, it's not technically a breach per se of the individual's private health information. However, it is a HIPAA violation because you are not supposed to be sending unencrypted CT scans or any other private health information through an email, text, or anything like that unless that information is encrypted or de-identified. You can send the scan if it says this is for patient 1, 2, 3, 4, 5, and it's not marrying that to a name or a social security number. If it's just marrying it to a number in a system somewhere, that's not necessarily a violation. But the bottom line is this: it's a very bad practice to ever email anything non-encrypted. And the reason I say this is patients are learning they can sue state by state, precedents being set, falling like dominoes, and under the accounting of disclosures, which is a federal law, it's the right of patients. If it did go that far and something did get breached, that patient sues, they get the accounting of disclosures, they will find out everywhere that private health information has been sent. It's their right. And if they find out it's been texted non-securely, if it's been emailed non-securely, you're opening yourself up to a lot of liability. Hence why very important to use encrypted portals when you're accessing your private health information. That's the best way to do it, not email at all. Now you can email, and there are reasonably priced email encryption systems you can use, but if you're not doing these things, you're just opening yourself up for liability. Because it's not hard to find partners who do offer HIPAA compliant solutions, that you can implement at a reasonable price for sure. So that's just a bad idea to be doing that.
Another question that came in is, how is HIPAA implemented with the recent breach of the federal employee security on the news?
Yeah, it's funny that they got to govern themselves, don't they? It's HIPAA. It doesn't have anything to do with private organizations or state organizations or any other entity dealing with private health information. You must implement the HIPAA privacy and security rule. And the way I recommend doing this, first thing you have to do, this is the first thing the federal government will ask you if you get a letter from the Office of Civil Rights. Number one, where is your risk assessment? Show us proof that it has been done. That's every single letter I've ever seen. That's the first question. That is the number one area of noncompliance. All entities dealing with private health information must do that risk assessment. That's the number one thing. By doing the risk assessment, If you do it right, you cover every single one of the implementation specifications of the HIPAA security rule, and there are 44 of them. You see what the organization is currently doing, what you need to do to mitigate that risk. And a lot of times you're doing things just fine. So what you need to do is write it down, take credit for it. If one thing for sure with the federal government, if it's not written, you're not doing it. So with the current breach at the federal government, they need to do their own internal risk analysis. And it's just, I mean, quite frankly, to be blunt, the federal government folks who enforce HIPAA half the time don't even know their own law that well. If I had a nickel for every time I've spent explaining to them their own law, I would have $2.45. It's frustrating, but it is what it is. And so they need to get their own house in order, but that really, what we're trying to do is to protect our businesses and our medical practices from them and get our house in order so there's nothing to see here, so to speak, and go down the road, go away. And that's the name of the game. And it's so important to be able to show that you have taken due diligence to protect this information. And don't get me wrong, it's very important to protect private health information. Problem is, the way the government implements HIPAA, it's all based upon taking reasonable and appropriate due diligence. What does that mean? It means a lot of things. What's reasonable and appropriate? Well, in my experience, it's the whole concept of being able to prove you're taking the law seriously and doing the best that you can to limit the risks and still be able to function your business and practice medicine. I hope that answered it. I know that was a very long-winded answer.
Okay, there are several other questions. Do you want to field them now, or should we wait?
Yeah, let's move forward and keep the questions, and then we can address them. They may get answered through this or somewhat addressed.
Okay.
So again, omnibus and risk analysis. Covered entities and business associates, again, must conduct periodic risk assessments analysis to address risks and offer mitigation, along with having adequate policies and procedures in place. And here you go, more vague words. What's periodic mean that the government doesn't say? The rule of thumb is annually. You should conduct a risk analysis on an annual basis or whenever any major technical, procedural, or legislative changes occur. And it's the legislative changes that tend to bite folks because we just don't know what's going on in Washington. Okay, next slide. So in 2012, there were 9,500 complaints received by the Office of Civil Rights of alleged HIPAA violations. And this is before patients could really sue under HIPAA. That number almost doubled in 2013 because in late 2013, the Omnibus rule went into effect. The last data I have here, as of July of last year, which was almost a year ago, just as of July of last year, more fines have been received from HIPAA, or more money, I'm sorry, have been received to the federal government from HIPAA fines in the entire history of the legislation. This is only going to get much, much, much worse because the government is doing the auditing themselves proactively, outsourcing it, and with the encouragement of patients, encouraging the states to ask the state's attorney generals to put in laws where patients can get, their citizens can get reimbursed for wrongful disclosures. That's going to get a lot worse with frivolous lawsuits and just frivolous accusations at OCR. So this was not a fun read, but I did read the 2015 Health and Human Services budget, and I don't recommend it, but nonetheless, the increase, this is the quote, the increase in funding will support the enforcement of HIPAA, the HIPAA security rule in particular. The budget maintains its current programmatic focus and also supports an initiative of enhanced enforcement of the HIPAA security rule. This is from the director of the Office of Civil Rights, and a gentleman named Leon Rodriguez. He's pretty hardcore here. This is a direct quote. With the revenue being brought in from the audit process, the federal government hopes to recoup losses for meaningful use, Medicaid, and Medicare payouts. That's disconcerting because the government says they will pay you to take the money to implement EHR. That's where the meaningful use dollars come in. That means if you implement electronic health records You use them in a meaningful way, the federal government will pay you $60,000 per provider, I believe is the number. However, if you do take the money, then we're going to come and audit you to recoup losses for the money we paid you for meaningful use, Medicaid and Medicare. So it's a very troubling quote. And then the other quote, I expect we are going to see large monetary settlements for a long time to come. So if you took meaningful use dollars for the adoption of electronic health records, the likelihood of an OCR audit is not really if, but when. However, if you're using it in a, quote, meaningful way, it does help you in your HIPAA compliance levels. So bottom line, government plans to make this a money-making venture to bring in revenue, and the outsourced firms and individuals, because I am one, working on contract with the government have a vested interest in levying fines. 4 million received in 2012, that's nothing really to the government. 6.5 million in fines in 2013, and again, as of July, more revenue brought in fines in the entire history of the legislation. And these, the above were prior to the increased budgets granted to HHS, and also prior to individuals learning that they can get remedied under their own state laws. So the trajectory is skyrocketing upward, and it's not going to stop. So let's talk about this real quickly. Omnibus and suing. This is the new thing that's probably the most scary of all of it, to be quite blunt. Currently, let me be clear, patients, individuals cannot sue under federal law. There is no private cause of action allowed to an individual to sue for a violation of the federal HIPAA or any of its regulations. This means you, being the patient, do not have a right to sue based on a violation of HIPAA by itself. What most people don't get about HIPAA is that as extensive as the statute is and as serious as its potential penalties are, at least for the medical practices and business associates, Congress, in its infinite wisdom, chose not to include a private right of action. But you may have a right to sue based on state law. And like I said, the federal government is now heavily encouraging states to pick this up. The omnibus modifications to HIPAA made no impact on an individual's right of action, no direct impact, but for all intents and purposes, it did. However, they do affect individuals in tangential ways because it grants states' attorney generals the ability to bring civil action and seek damages on behalf of their residents for HIPAA violations. So, again, currently they can't sue under HIPAA for wrongful violations. Uncle Sam will be suing under HIPAA. Uncle Sam will be getting paid. Patients will be suing under state law. So, this clearly is an issue. Attorneys will be trying to cash in. This will most certainly increase the possibility, clearly, of HIPAA audits for the business or the practice. Even frivolous accusations can spurn an audit, such as patient files false complaint to OCR looking for easy settlement. Worst case, or best case scenario, I mean, it doesn't do anything there, but you're still on the radar of the federal government. We don't want to be there. For example, here's how HIPAA is used in a court case. This was recent. 1.44 million with Walgreens. Husband contracted an STD from an ex-girlfriend. The angry wife knew the pharmacist to access the ex-girlfriend's medical record. The pharmacist told her that worked for Walgreens. Therefore, jury found Walgreens clearly guilty. This is important as it sets precedents for many more instances where HIPAA can be used for justifying a court case. Here's a couple examples. I just learned that my manager at my doctor's office told my friend about my recent visit to the office. I thought that my private health information was supposed to be kept confidential under federal law. Now my friends are talking about it and I am humiliated. Can I sue the doctor or his office manager? Is there anything else I can do? These are real questions that I've received. Answer. HIPAA rules are intended to protect the privacy of personal health information held by the covered entity or business associate as well, such as your physician's office. It gives patients a wide array of rights with respect to the information while permitting disclosures under certain specified circumstances, which need to be laid out in your notice of privacy practices, by the way. That's for covered entities. Unless the disclosure was permitted under the privacy rules, such as disclosures to another healthcare provider for purposes of treatment, or disclosures for purposes of payment or operations of the provider, or any of the other permitted disclosures under the rules, a disclosure by the office manager to your friend would not be permitted without your consent or authorization. Violations of HIPAA privacy rule carry significant penalties, including civil, money penalties, so criminal fines and prison time. So clearly, yes, that's something that could be used in a lawsuit. Absolutely. This is redundant. I won't read this again. I accidentally put this in here twice. So state laws falling like dominoes, individual courts being filed all the time, citing HIPAA violations and creating precedents. I've been sitting in and been asked to sit in as expert witness on multiple cases going on now, and it is just upticked exponentially as of 2013, the amount of these court cases going on. From a personal perspective that I've been pulled into, and from, you can just look it up online and see things that are happening state by state. If the violation, in terms of private legal remedies, if the violation resulted in damages, meaning you suffered some kind of verifiable financial loss, you, the patient, may have a civil claim against the individual who violated your HIPAA rights. So here's the course of action. I'm not going to spend a lot of time on this, but the reason this is so important to understand that why state law is so important is because the course of action under state law, number one, is to file a HIPAA privacy complaint with the Office of Civil Rights. Therefore, it's filing with the federal government. Even though the individual doesn't get paid, they need in their state court case for the feds to say, yes, this is a HIPAA violation. So the patients will be instructed to file a complaint with the federal government. They're usually required to be filed within 180 days of the event. They're usually all taken and fully investigated. And if it's egregious or repeat violation, it may even result in an investigation by the FBI. I have seen this. And also the states, whatever state you're in, that the state's Bureau of Investigation, and criminal charges being filed against those responsible. However, in most cases, if there is a valid complaint, the federal government will assess administrative fines against those responsible, typically the medical practice or the business associate. In almost all cases, a report will be made back to you, being the patient, of what is found and what actions have been taken. Next step, they're going to file a complaint against the physician involved with the state's Department of Health. So now you get to deal with the Department of Health in your own state. So the DOH typically licenses all physicians, nurses, and health professionals. It also is responsible for investigating complaints against them. The various professional boards are Board of Medicine, Board of Nursing, etc. These are all under the Department of Health. And if there was a violation or breach of patient confidentiality or medical records confidentiality, it also may be a violation of that state's laws on patient or medical records confidentiality. And you can rest assured most states are going to be parroting the federal HIPAA laws. That's typically how law works. So DOHs typically work the same in most states. Then the patient is going to file a grievance or report to the third-party payer. So if the individual is a Medicare patient, it could be TRICARE, CHAMPUS, Veterans Administration, Public Health Service patient, military patient. They may also report to the Office of the Inspector General of that agency. If the patient's a member of a managed care plan or have health insurance, they may file a complaint or grievance with the insurance company, because every physician who accepts Medicare is subject to the Medicare program's peer review system. They may file a complaint directly with Medicare and ask it to be reviewed by the Medicare peer review program. So you can see as we keep moving here why HIPAA and security of PHI is so important now when patients are going to learn this. Next thing is the state law and lawsuits for the civil recovery. So if the violation or a breach of patient confidentiality or medical records confidentiality, there may also be a violation of the state's laws on patient or medical records confidentiality. In most states, this would give you a legal course of action for invasion of privacy or for negligence. Documentation clearly is key. So the patients would be asked to keep doctor's bills, mental health counseling fees paid, the purchase of credit protection if it was an identity theft, purchase of identification theft insurance, costs paid because identity was stolen, lost pay from time off, lost pay from a lost job. You may ask, Why would you lose a job? Well, maybe a background check company, this has happened, called a medical office, asked about a patient's medical records, and found out that patient was going under treatment for cancer, or that person going for the job. Well, they nixed the contract, didn't give them the job. The individual found out, and as you can see, that didn't turn out too well for the business that was doing the background check. Moving forward anyway, attorney's fees obviously is a direct result of the breach, and other actual out-of-pocket expenses. These are all things that attorneys are asking patients to do in the event of a breach. So what are factors that can spurn an Office of Civil Right audit? What are things that can cause you to get audited as a medical practice, a dental practice? It doesn't, whatever you are, these are the bottom lines here. Internal staff clearly is number one. Internal staff's your biggest problem. That's with any business though. That's not just medical. So you may have disgruntled staff members. You may have staff members who talk too much, who screw around on social networking too much, who don't understand the law, don't understand their personal responsibility. So what are we going to do to limit those risks with the internal staff? Well, education. That's number one. Let them know of their personal responsibility. Hire well. Do not ever hire anybody that's going to be privy, and in my opinion, privy to private health information unless that you've done a background check on them. You don't want to hire people with shady pasts that have access to thousands of social security numbers and thousands of health records, because if a bad breach occurs, that is not going to look good, not at all. And you know, it's an addressable aspect of HIPAA to do background checks. Addressable means you do not have to implement it, but you must address why you are not implementing it. You know, it makes sense. You don't need to do a background check maybe if the dad is the doctor, the mother's the practice manager, and the daughter's a scheduler in a small town. No, you don't need to do it then. Then you address why we're not. But if you're a larger organization or even a medium-sized organization with reasonable turnover, you need to. That's just one example of internal staff. That's your biggest problem. Make sure all staff sign your confidentiality agreement, understanding the personal, civil, legal liability and criminal for wrongful disclosures of PHI. Your patients are big problems. I mean, they know they can sue soon. You know, you've got patients who are very upset. Patients may see their medical record sitting right side up. You may email things to them non-securely. You never want to do that. Patients may overhear verbal discussions really loudly about their private health information above incidental disclosure. Patients may be looking for some reason to, I don't know, they could carry their phone around and take pictures. So very important to how do we limit risk here? Well, very, very good customer service, great bedside manner, act professional in your practice, act professional, look professional, dress professional. Patients who love their doctor, love their dentist are much less likely to cause an issue, even if some areas are lax. So very important to do that. Set your practice up strategically as well, where the chairs in the waiting room are moved physically further away from the front desk. Have a TV playing. You know, maybe you have a TV in your lobby and you put it in there just for entertainment reasons. Well, when I see a TV and I write up a policy, I say, no, we put this TV in here to increase noise to limit the risk of verbal disclosure, of incidental verbal disclosure. That's what I see. I take credit for it, put it in policy. Anyway, let's move on to meaningful use. I don't know if we're dealing with primary dental practices, this isn't going to apply, but meaningful use, again, that is the money given out for medical practices to implement electronic health records. If you took that money, there's nothing you can do to limit risk. However, by implementing an EHR based on their very design, they do help you in your HIPAA compliance levels, at least as it relates to information technology. Business associates, this is very, very important. Make sure that you are using good business associates. Make sure and ask questions of your business associates. Make sure and ask your business associates to show you some sort of proof that they are, in fact, HIPAA compliant, that they have done their due diligence, they have done their risk analysis, they have put policies in place. It's very important. Even though if there is a bad breach on a business associate, yes, they're going to get fined as of the new HIPAA Omnibus rule because they're under the entire scope here of this law as are covered entities. But a bad business associate then can reflect extremely poorly on a medical practice. Do not pick your business associates very, very carefully. Don't go with groups who are not or fumbling around or not real sure of their responsibilities under HIPAA, because you can rest assured that they probably don't know. So that's very important to have good business associates. If you've had a previous or a current breach, that can cause a spurn an audit, obviously. If a breach, especially of a magnitude occurred, yes, it can cause an audit, but not reporting a breach is big, big, big trouble. Do not, if you have a breach, remember, report the breach. Go through the breach notification policy. It's easy. It's not the end of the world. And to be honest with you, this is paradoxical, but especially larger practices, if there's never, ever, ever, ever been an incident of a PHI wrongful disclosure, and you've been in business 20 years, that looks kind of funny. In fact, it's almost better to have had incidents occur which you have addressed and that you have fixed, or that you've at least said an incident occurred, but this was not a breach. That actually looks better in a weird way when audited than having a larger business or a larger medical practice that nothing has ever occurred. That's just very unusual. And a disaster, if a disaster occurs and it does not go well, that can be a big problem, because it is a patient's civil right to have access to their private health information. Therefore, if you have electronic health information and you are not backing that up adequately, for example, the server gets hit by lightning, it gets flooded, or God forbid, say a tornado or fire, but you have no backups, guess what? That is a major, major violation and a huge fine if you lost all that information. When a disaster, as it pertains to HIPAA, you must have a written disaster recovery plan as it relates to private health information. Here's how we're going to get our information back in a timely manner, in a reasonable and appropriate timely manner. There's a lot involved on that. I don't have time to spend too much, but you must have a written disaster recovery / contingency plan under HIPAA. So hypothetically, what's involved with an audit? I keep talking about this, but what's involved with it? And this is straight from the hhs.gov, and this is how it works. Depending on the size and scope, site visits conducted as every audit would include interviews with leadership, which definitely would include the practice manager, the HIPAA privacy officer, the HIPAA security officer, which is usually the practice manager in a smaller group, the chief information officer, or IT. It could be outsourced IT or in-house IT, legal counsel, medical records manager, examination of physical features. That means walking around physically looking for low-hanging fruit, looking for the physical security of the organization, consistency of process to written policy. The reason that's in red is you do not want to use cookie cutter policies that may say the right things but are not being implemented, because auditors will look at your policies. If your policy states that we audit, or we audit our system on a monthly basis to make sure that user action is appropriate within our practice management system, but yet when you're asked to do so, you don't even know how to do it, that doesn't look good. So anyway, an observation of compliance with regulatory requirements. So far, small providers, I mentioned this earlier, have had many more issues than larger ones. Healthcare providers and business associates have had many more issues than clearinghouses or plans. And I see this as well. The run-of-the-mill healthcare providers and the business associates have many more issues in terms of their levels of compliance and doing hundreds and hundreds of these things in real life. That's what I also see versus when I audit clearinghouses or plans. The HIPAA security rule, which is the more information technology aspect of this, is by far the biggest concern compared to the HIPAA privacy rule and the breach notification rule. So in terms of specifics and drilling this down, the number one area of concern in the first wave of audits, I shouldn't say wave of audits, because if it's a wave, it's a tsunami, because it's basically, this isn't going to end, it's going on and on. One reason it's not going to end is the federal government's making too much money on this. And I don't know the exact accuracy of this statement, but I read this, and I can't remember where I read it, but for every dollar the federal government has been spending on the enforcement of the HIPAA privacy security rule, they've been bringing in 20 in revenue, which makes sense considering it's being outsourced. So they're not really paying themselves. They're not using their own resources technically to do it. And because it's such a gray law, there's too many areas that can be found of wanton neglect. And quite frankly, most folks have not taken this law very seriously all these years, because why would you? It's been benign, like I said, for so long. Anyway, that's number one, risk analysis not being done. Number two, lack of written policies. Like I said, don't use cookie cutter policies. Make sure they're consistent with your procedures. Number three, lack of staff training. Train staff upon hire, train staff on an annual basis. Make sure they sign off. How should training be done? Doesn't matter. You can do it online, in-house. You can call in an outsourced person to do it. However you want to do it, it's got to be done. Lack of a written contingency plan or / disaster recovery plan. Must have that, must be in writing. Lack of proper system auditing. System auditing clearly means you have the ability to go into your system, your practice management system, or your electronic health record system, and make sure that user Brian, like me, isn't going into my ex-mother-in-law's chart that I have no business accessing, because if I'm doing that, I'm violating her civil rights. Unless I had a reason to be in that chart, you audit the system, you see I've been in there, I need to be sanctioned or perhaps fired. Some folks go as far as firing people. And breach notification, number 6, meaning if a breach occurs, you must notify. I added this, weak IT support, because I see this a lot in my experience, and I've, again, done hundreds and hundreds of these things. Don't trust your IT people. Learn what they're doing, because it is so important, because IT is a big spoke in the wheel with your compliance levels. Don't trust them when they say backups are good. Make them prove it. Say, okay, well, show me. I want you to do a live extrapolation. Make sure they don't have ports open that shouldn't be open. You need to have again, that's why risk analysis is so important, because it's just checking even down to the granular IT level to make sure you don't have port 3389 open to a public IP address or something, not to get too geeky there, but that's very common. And that means any kid in Indonesia can run a port scan on, and they are doing this, millions all day long, or viruses are out there running port scans looking for open doors, and there you go, you got an open door, then you just have to hack the username and password. Okay, I won't get in too geeky there. So what if the feds do come knocking? And by the way, they're not going to come knocking. They're going to send you a letter first, and I don't want to make them sound like the Nazi Germany here. That's not the case. I mean, they're reasonable as long as you're reasonable and you've been proactive, but you would first get a letter, or a written letter from the Office of Civil Rights. So if they're going to come audit you, what do you want to do? Gather all your documentation, employee handbooks, business associate agreements, business associate list, meaning the list of your business associates, educational documentation, confidentiality agreements, which have hopefully been signed by your staff. And if you're a covered entity, you would want to have your notice of privacy practices ready, and hopefully it's been updated since September 23rd, 2013, because if it has not, it is not compliant. You want to review your HIPAA policies, update as needed, be sure all implementation specifications are addressed. There are 44 HIPAA security rule implementation specifications. I recommend going online, Googling that, and reading each one. There are a lot of them that are redundant. This is not rocket science. It's just something we have to do and work through and get it in place. Even implementation specifications that are not required, because not all of them are required, but even only the addressable ones, you still need a policy as to why they have not been implemented. Have your risk assessment handy. Hopefully you've done one. If it is not available, get one done ASAP. Outsource it if you have to. Be sure the assessment is adequate for both HIPAA privacy rule and security rule. Bring in a consultant or an attorney if needed, and don't bring in a divorce attorney. Attorneys are very unclear about this law. They don't even know it very well. So you need a specific attorney if you're going to do that understands this law. Prepare your staff, explain to them what to expect, be sure they know your policies, explain to them about, quote, low-hanging fruit, which I'll talk about in a minute, and let them know what to expect, what to be trained, understand that this is a personal responsibility. Be nice. Don't be surly, obviously. Don't be mean. Don't be defensive. Bring in outsourced help can help greatly increase the, quote, reasonable and appropriate due diligence if you need someone on hand there to sit with you as a consultant to help. If you do bring in a consultant or legal counsel, make sure they are familiar with the specifics of HIPAA. HIPAA is a very strange law. A does not equal B with this law. A equals whatever the risk assessment says it equals. A, for a small mom and pop practice in southern Louisiana, does not mean the same thing as it means to the giant, I don't know, Dallas-Fort Worth hospital. So, but the law is the same. We still have to address it the same. Okay, low-hanging fruit. Now, these things are not the, quote, 10 commandments or whatever written in stone, okay? But these are areas that would be HIPAA violations unless you can explain why you're doing it. Password sharing. Never share password. You should never share passwords unless you're in an ER perhaps. Because if I know your password, I can log in as you, I can steal identities, I can do anything in the system. If you audit the system, guess what? It turns out that you did all these things because that's your username and password. You should never share passwords. You should never have too many admin passwords. Users should only have enough access to perform the job function. That's called the minimum necessary standard. There should only be one, maybe two super users of the system, unless your practice is so small that you need to have cross-training and several people do need that. That's okay, but we need to write in policy why that's being done. Passwords not complex or changed often. Don't use 1, 2, 3, 4 as your password. You should use 8-character complex, changed at least every 180 days. Complex, of course, meaning uppercase, lowercase, number, symbol, the annoying ones. Bad backup policies. Make sure your backups are good. That can be catastrophic if not good, not only for the HIPAA compliance, but for your business in general. No auto log off or screensaver. If you have machines that are accessing, transmitting, or storing private health information, that screensaver should go to a password protected screensaver after no more than 5 minutes. There's no concrete law that says that. That's just a best practice. Non-encrypted email texting. Do not email or text in a non-encrypted fashion. Bad business associates, we've been through this. Don't have bad business associates. Make sure and vet whoever you're doing business with because it's important for you. Make sure they've got their HIPAA house in order, so to speak. Where's your server? Is it in a secured area? Is it locked? Is it next to a window, next to a wooded area in a high crime location with no alarm system? That would be very bad. You would get fined for that. So make sure it's in a secured area. Where's your paper-based private health information? Is that in a secured area? Are your screens, with your computer screens, are they physically turned adequately to a degree? Do you have a TV or some kind of ambient noise within your practice? If your dental practice is typically, when I write in policy, I say inherent to a dental practice is all the noise of the drills and the cleaning going on. It helps limit the risk of incidental disclosure and take credit for it. And I mean, I keep saying these things, but these are things that the auditors love to see. They love to see the little I's dotted and T's crossed. It gives them a warm, fuzzy feeling. That's just how they think. I've learned this over the years. No window at check-in. You don't have to have a window at check-in, but if you're an infectious disease or a psychotherapy clinic, you absolutely need a window at check-in. Very secure in those areas, in those types of medicine. Staff ignorance in an interview. Web-based services utilized are not encrypted. Do not have any partners that offer web-based services that transmit private health information unless encryption is used. Some still do that. Some still say, come on in through remote desktop access through non-encrypted channels. I see this all the time. Very, very bad. Make sure you're using, again, good business associates. Mannerisms of your staff. Voice level. There's always the loud person, you know, and keep the voice level to the minimum necessary. Do not talk about private health information before entering an exam room. And I know dental offices may be different. There aren't exam rooms, but keep it, you know, down to the reasonable level, minimum necessary. Lack of adequate paperwork. What I mean by that, do you have up-to-date business associate agreements? If they're not up to date as of September 23rd, 2013, they need to be updated. You can go to hhs.gov and get an excellent little template of a business associate agreement, or you can email me directly and I'll send you one. Outdated paperwork. Is your notice of privacy practices up to date? If not, that needs to be. Do you have updated HIPAA authorization forms? Lack of an alarm system if deemed reasonable. If you're in a high crime area, you don't have an alarm system on your practice, guess what? You could be fined for that as not taking reasonable and appropriate physical risk mitigation. Lack of system auditing of systems which contain private health information. External media not encrypted. Never take an external drive, laptop, anything off-site that contains PHI unless it's encrypted. It leads you, just opens you up to an enormous amount of risk, and it's so simple to encrypt. Outsourced access. How are your outsourced partners getting into your practice? How do they come in? Is it encrypted? Is it through a secure VPN? Or are they coming in through the World Wide Web through some sort of open portal that's not encrypted, or through remote desktop that's not encrypted? Historical records, where do you keep those? Do you abide by the minimum necessary standard, both verbally and electronically? Is your data encrypted at rest as it sits in your database? Antivirus not installed or not robust. Don't go cheap here. Use good enterprise level antivirus. Is your external firewall on your practice or business, is it adequate? Is it, you don't want to use a $30 Linksys from Walmart, which sits in front of your server with thousands of health records. No, you want to use an enterprise level Cisco, SonicWall, FortiGate, I don't know, there's lots of them out there. You should do pen tests, penetration, that's what that means, penetration tests against your practice, emulating a hacker. Lack of risk assessments, clearly. Lack of written policies or procedures, clearly, that's another issue of low-hanging fruit. So, getting to the end here, risk assessment, do it. A risk assessment is not only required, but is the best way problems can be found and mitigated. There's no surefire way to do the assessment, but make sure all areas are covered. This is the first thing the feds will want to see in the event of a breach, and the first thing they will ask for in an OCR letter of just a typical audit, regardless if a breach occurred. Should be done annually. So, in conclusion here, let me be clear, there is no such thing as 100% HIPAA compliance. It cannot exist, especially with a covered entity, because of the risk of incidental disclosure and so many other ways information can be overheard, accidentally done in the course of providing health care. This is straight from the federal government. Covered entities and business associates are just expected to follow the security and privacy rule standards, implement proper policies, procedures, and technologies, and reasonably, this is key here, reasonably show the organization is making an effort to protect against common threats and vulnerabilities. Those two words, reasonable and appropriate, are used all through the legislation. The government just wants to see that you are taking reasonable and appropriate measures to reduce risk. That's the key here. So best course of action, and again, I've said this 1,000 times and I'll say it 1,000 more times, be proactive, conduct that risk assessment. That's the first thing you've got to do. Do it annually, conduct the risk assessment, get your policies in place that accurately reflect the procedures, train your staff, audit the systems, hire good people. That may even be number one, really. Hire good people and be reasonable and appropriate. That's the key words. So I will open this up for Q&A. If you ever want to visit my website, anyway, it's HIPAA-consulting.com. But I know you guys may have some questions, and I know I went a little longer than anticipated, but I am a talker, I guess.
Okay. Yeah, there are a bunch of questions. So let's get started. The first one really addresses Big Box directly. What is the proper way of sending or receiving email x-rays from one dentist to another?
If possible, through some sort of portal or using a group such as Big Box and logging into that portal where the information is sent into the portal. Then you go into the portal and you get it. It's all encrypted. You have no risk there. Zero risk. That's the way to do it. That's the way I recommend, period. If you're going to do the old-fashioned email, then you need to encrypt those things prior to emailing, which is a headache and it's expensive.
The next question that I know you discussed already, but maybe just reiterate the point. Where is a good place to get information on how to set up risk analysis, policies, etc.?
Well, I can be your resource for that if you want. HIPAA-consulting.com. Bottom line is, if you look up individuals, make sure they're vetted. Make sure they're not selling you snake oil and trying to charge way more than is ethical. When you're looking folks up, just Google, quite frankly. There's actually a tool on healthit.gov if you want to do it yourself. It's a handy tool, healthit.gov, and Google risk assessment, and you'll find a little tool that the federal government has. It's kind of, I don't really like it, but it's free, and you can try it there as well. But if you do go with a consultant to do the risk assessment, I recommend getting references and make sure that folks they're vetted and they're charging you a fair price and not a ridiculous amount, because there are a lot of groups out there doing that right now. Next question.
Is the built-in encryption on cell phones enough to comply with compliance standards?
At this point, yes. However, there are new laws coming out. They're on the white papers right now as it relates to mobile devices, because the government's typically 4 or 5 years behind reality before they get the actual laws out. But currently, yes, they are. 256-bit encryption is the rule of thumb. But there's nothing in HIPAA that says it has to be 256-bit encryption, and that's not real high encryption. But yeah, there's a lot of there's a lot of other third-party encryption services you can use for cell phones or smartphones. I don't have any off the top of my head, but again, just like with a consultant, look them up, get good reviews, and go from there if you're going to implement that.
And what you're saying now applies to both voice and text?
Pardon?
What you're saying now about the security of cell phones applies to both texting and speaking over the phone?
No, not speaking, just texting.
Okay, so there's no issue with texting and there's no issue with speaking either, I assume.
Well, you don't want to text private health information unless you can speak over a cell phone, private health information, but not text. Those go through different channels.
So texting would be problematic.
Yes, texting of private health information, identifiable private health information, non-encrypted, is not secure. It would be very difficult to get caught doing that, but if a patient if there was a lawsuit that came though, and a patient were to sue, and this stuff can be ascertained through discovery, through Verizon or whoever your provider is, and you can see those text messages. So, you know, if it got to that point, it would be difficult, but it's a very bad habit, and it's going to just flat out be forbidden. Now, if you're going to do these things non-securely, you can have your patients sign a form stating a request for confidential electronic information, which the form states that I authorize you to email, text me this, that, or this. I understand that it's not in a secure method, but I am authorizing you to do this. I don't recommend going down that road, though. It's just not, it's not that expensive, and it is, quote, reasonable and appropriate to implement measures to do secured texting and emailing. And that's going to be the new norm anyway.
Okay. Next question is, a lot of patients give us old insurance info and or terminated info. Is that a violation on our accounts?
No, not if the patient's giving you the information. No.
So it's not the responsibility to confirm that the information being received is accurate in any way.
Well, if the patient's giving you inaccurate information, that's the onus is not on the provider. No. There's not a HIPAA violation anyway. It would be good to know because you want to get paid and reimbursed for your services, but it wouldn't be a, quote, HIPAA violation.
Okay, the next question is, how can I get copies of this information? So this presentation is actually being recorded and will be live on YouTube tomorrow. In addition, I think you could visit the website, HIPAAconsulting.com.
HIPAA-consulting, yes.
HIPAA-consulting.com and get more information as well.
Yes, absolutely. And if you have any HIPAA questions, you can email me directly through there, or if you have any questions for Michael, you guys know how to get in touch with him directly.
I'd like to ask that everybody complete the webinar attendance form. The links are underneath the video windows so that we can distribute the CE credit, and you should be receiving the CE credit via email within around 1 week's time. In addition, I'd like to reiterate what I mentioned at the beginning, that we've recently launched biobigbox.com, which is a HIPAA-compliant file transfer and storage system, which led us to this presentation on HIPAA compliance, a very important and relevant topic. Brian, I'd like to thank you very much for this tons of information that you gave over. I think it's extremely pertinent and relevant, and thank you very much for the time and information.
Absolutely.
I'd like to wish everybody good evening, and thank you very much for attending.
Thank you, guys. It was nice. Enjoyed it.